of Tennessee is now in session.
Excuse me. Good morning, Council. Before we start, we don't anticipate any technology problems, but if we should have any, just everybody take a deep breath and our experts will work through it and then we'll pick back up. Things have been working very smoothly though. So, Stephen Colin, first case, please.
Nelson E. Bowers II versus the State of Katherine N. Mounger.
We'll hear from the appellant.
Good morning. I'm Darrell Fansler of the Knoxville Bar. I represent the estate of Katherine N. Mounger. This case has been before this court on one occasion before. It involves a sale and purchase agreement of approximately 1,300 acres in Roane County, Tennessee. The purchaser was a LLC known as McKenzie Loudon Properties. Mr. Bowers is the assignee of the membership interest in that LLC. There is no question but that at the time this deal was scheduled to close, the seller was unable to deliver marketable title. That's because Charles Mounger, the brother of Dr. Mounger and Dr. Lassiter, who resided on a portion of the property, orally claimed to have a title or a deed to portions of the property, particularly an area where the developer intended to put a boat dock in this residential development. The contract was entered into on May 9th, 2007. It provided for a 120-day due diligence period. At the end of that time, the buyer could exercise an option to extend that another 30 days if they paid an additional $50,000 in earnest money. And they did so on September the 5th, 2007, exercised that right and got an additional 30 days on the due diligence period. Now, this paragraph or section 4 of this agreement provided certain things. Number one, it said that the earnest money was not refundable except for the terms in that paragraph. It required that the buyer do a title examination within 30 days and within 10 days notify the seller of any defects in that title. Now, there's no provision in that for someone making an oral claim to own it. Had they done the title search, there's no question but that Charles Mounger's claims would not have shown up because he didn't record this purported deed until after the date of the scheduled closing on November the 7th, 2007. However, we all agree, I think, that the law says that we look to the spirit of the agreement and not to the letter of it. Clearly, what this contract provided for was that the buyer had time to do the due diligence. If they found a defect in the title, they had certain options. The first thing they were required to do is tell the seller so the seller could do one of two things. Have 30 days to cure it, and if they couldn't cure it, they would tell the buyer that they were not able to cure it or would not cure it. So then the buyer had an additional 5 days to say, we accept the defect and want to close. Now, what happened here is that in August of 2007, almost 30 days prior to the extension of the due diligence period, Harlan Rice, who was an employee of MLP, McKenzie Loudon Properties, received an email advising that Charles Mounger was claiming to own part of this property. Now, Mr. Rice testified by deposition, and he said that he forwarded that email to Dr. Lassiter. However, we produced at trial a copy of that email, and it clearly shows that it was not forwarded to Dr. Lassiter until March of 2010, long after this whole contract and the clearing of the title and so forth had lapsed. Mr. Rice testified that he had a lot of discussions with the members of MLP, Mr. McKenzie and Mr. Steele, and that they told him that they intended to close on this property despite Charles Mounger's claims. Now, in early August, August the 3rd, John Anderson, who represents Mr. Bowers as well as others, apparently left a voicemail for Archie Carpenter, who at that time was representing the estate. In response to that, Mr. Carpenter wrote a letter to Mr. Anderson the next day saying, if Charles Mounger interferes with you anymore, let me know and we'll take action. Now, the trial court concluded that somehow from that conversation that Mr. Carpenter knew that Charles Mounger was claiming an interest in his property. That's the court.
Counsel, I mean, what else could it mean?
Well, there was no mention at that time of any claim of Charles Mounger. Mr. Carpenter's letter says that if he interferes with the geotechnical person, as he did, as you said he did, then we'll get an injunction for keep him from interfering with your due diligence. Didn't say anything about a claim of Charles Mounger. And in fact, John Anderson and Mr. Convalinka are good lawyers. I find it hard to believe that they would not have made some stated disclosure to Mr. Carpenter if that was the fact. And no one has ever argued that John Anderson told Mr. Carpenter of Charles Munger's claims in that telephone conversation on August the 3rd. In fact, the trial court found that the buyer MLP was unaware of these claims until August the 9th, 6 days after Mr. Carpenter sent his letter. So there's nothing in this record that you could conclude that Mr. Carpenter or the executors of the estate knew of these claims until October 31st. Plaintiff even says in his brief that it's undisputed that they knew on October 31st. Dr. Mounger, Dr. Lassiter testified unequivocally that that was the first knowledge they had that Charles Mounger was claiming to own part of this property. Now, clearly,
they thought he was just they thought he was running. Was it the surveyors off? They thought that he was just kind of running these folks off for fun.
Yeah, the email said he was out there with a shotgun, told him it was a dangerous place.
Yeah.
And that's all that could be, Mr. Anderson could have stated. And by the way, Mr. Anderson testified in this trial. At no time did he assert that he told Mr. Carpenter on August the 3rd or at any time prior to October the 31st that Charles Mounger was claiming to own part of this. I can't believe the caliber of lawyer of Mr. Anderson that he would have just not said anything about it, written letters and made all kinds of demands. So we've got a situation here that this is really no different, Your Honors, than if they had had a title examination done that disclosed a defect and they never notified the seller of it. Then you come up at the day of closing and say, oh, by the way, you've breached this contract because you can't deliver a marketable title. They knew almost 3 months in advance of the closing date of Charles Munger's claims. They paid an additional $50,000 in earnest money to extend the due diligence period, and then showed up on October 31st when the bank appraiser, actually is how this all came to everyone's knowledge. The bank appraiser said, we can't loan you the money. I mean, this is a $15 million deal on 1,300 acres of property. It's not a vacant lot somewhere. This is serious business. And what the buyer did in this case, MLP, I'm not talking about Mr. Bowers, I'm talking about MLP. It's clear that McKinsey and Steele, without the advice of their lawyers, thought they'd just go ahead and get this deal closed and record their deed, and they win the race notice provision in closing this deal. They wanted to do it. They accepted it under the spirit of this. They failed to allow the seller almost 3 months to either cure or tell them that they couldn't cure. And then 7 days before the closing schedules, they say, oh, by the way, Charles Mounger claims to own part of this. And all they had to do was terminate it at any time. All they had to do was say, hey, we're going to terminate this agreement because there's lack of marketable title. They didn't do that. In fact, after this was all disclosed, they continued to want to deal on it. Mr. Carpenter did Herculean.
Pastor, let me interrupt you a second. I mean, did the trial court not find that that's exactly what happened, is that both sides continued to try to work it out past?
Well, I'm sorry.
Trial
Trial court found that after the closing date, they did continue to try to work it out. But now, Mr. Bauer, both sides did. Well, Mr. Carpenter got the title cleared in 7 months, which was a Herculean task, I think. But now Mr. Bowers takes the position that terminated on November the 7th on the closing date when we couldn't give title. And so therefore they didn't have to terminate it. They didn't have to refuse to.
Did there come a point where the buyer requested a written extension, something to the effect of, the closing be extended to 10 days after?
Absolutely. 10 days after it was cleared, Mr. Carpenter tried the case. The time for appeal ran. He wrote Mr. Anderson, said, we're ready to close. And as it turned out, they said, we're not interested. Of course,
well, but if they requested a written extension for 10 days after the time Mr. Munger's claim was resolved. Is that right?
They did, yes.
Did they get that written extension from the seller? I don't think there was one, was there?
I don't know that. No, there was never a written extension. No.
Okay. All right. You have your time for rebuttal. Thank you. We'll hear from the appellee.
May it please the court. My name is Lawson Kamalika, and I'm here on behalf of Nelson Bowers. So appellant stated in his argument and in his brief, devoted a good bit of time in his reply as well to the assertion that the trial court solely, almost exclusively relied on the Archie Carpenter letter for his basis for determining that the estate knew well before October 31st about Charlie Mounger's claims on the property. That's not true. The trial court relied on multiple things. He mentioned the letter to discuss the context of the first interaction with Charlie Mounger, to discuss the interaction between the parties. But the court also cited Harlan Rice's testimony. And Harlan Rice's testimony was that in August, he forwarded that email to Katherine Laster and also had multiple conversations with her. Now, Mr. Fansler says the email that was produced at trial showed that wasn't true. But Harlan Rice's testimony was that he forwarded the email immediately. And then in 2010, when they were having other discussions about things, he forwarded that email again. So the fact that he has a 2010 email does not negate or disprove that he forwarded an email in 2007. And the trial court apparently believed and determined that Harlan Rice was credible. This wasn't a mistake in the sense that he ignored what Katherine Laster or Jay Mounger's testimony was. The trial court laid out, we have two parties that are saying they learned about Charles Mounger's claims on October 31st. And then we have this other person, Harlan Rice, who says that he informed the estate in August of 2007 of the claims. And the court determined that indeed the estate did know about that in August.
Counsel, what does the record show? I mean, when did your client's predecessor, tell the seller deals off because of this problem with Mounger?
Well, the deals off, it was much after the closing. So again, Mr. Fansler is correct in that both sides were attempting to still get the deal done, despite Charles Mounger's interference. And so that, I don't know if there was ever an explicit deals off. There was an explicit, please return our earnest money. But that was, it postdated the closing by, 8 months, 9 months. The appellant's reply brief says that the court essentially negated the veracity of Jay Mounger's testimony about learning on October 31st. And that's true. We agree with that. The trial court did essentially negate the veracity of both Jay Mounger and Katherine Laster's testimony that they first learned about Charles Mounger's claims on October 31st. And that is the right of the trial court to make that credibility determination. That's the role of the trial court. And this court gives great deference to those decisions of the trial court. The trial court it was reasonable for it to make that determination. You have two parties that are interested, giving self-serving statements, and then you have Harlan Rice, who has nothing to benefit or will suffer no loss by the outcome of the case, giving alternative testimony that conflicts. It was well within the court's right to determine that it believed Harlan Rice over the Moungers. And it was also reasonable in the sense that the court understood the context of this proceeding, in the sense that they were administering an estate. They were siblings with Charles Mounger. It is reasonable for the court to conclude that Katherine Lassiter and Jay Mounger knew about Charles' claims on the property when they were administering the estate that involved the property in question. So the court's conclusions were reasonable. And again, it was within the purview of the trial court to make that determination that Harlan Rice was credible. Further, I will say this court has as well determined that that the state knew about Charles Mounger's claims prior to October 31st. In this court's 2012 decision in Mounger v. Mounger, and I have the site if you would like me to read it, this court, in its opinion, said that during the due diligence period, Charles Mounger confronted an appraiser, and that appraiser informed the estate of Charles Mounger's claims of ownership of the property. And again, the court made that decision. I don't have the technical record in that case in front of me, but
give us the page site. Give us the site to that, please.
It's 212-10 app, and I have the Lexus site, which is Lexus 159.
Okay.
And obviously this court, can take judicial notice of public record of prior litigation. The authority to do so is in the Tennessee Rules of Appellate Procedure 13C. There's also a case, State ex rel Wilkerson v. Bomar, which is 213-10-499. It's a Tennessee Supreme Court decision from 1964 that said the appellate courts can take judicial notice of prior litigation. The logic would apply to the same parties in the same substance of that litigation. So this court also made the same determination prior that, Jay Mounger and Katherine Lassiter did know prior to October 31st about Charles Mounger's claims. And that's important because as Mr. Fanzler is indicating, they had more time than just from October 31st. They had more time to address the issue of Charles Mounger. And the trial court did not place any blame on them for moving slowly with regard to that. But in response to the appellant's allegation that that MLP was hiding the information, that's simply not borne out by the record. Now, the appellant's brief also, changing topics, the appellant's brief also focused in and said that the trial court did not make a determination that the estate materially breached the agreement. And that's also incorrect. The court did not use the explicit term material breach. That we will concede. But, and I think it would have made your lives easier, my job easier had it done so, but an objective reading of that ruling will lead you to the same conclusion. It talks about 3 breaches, and it says 2 of those breaches, it goes to great pains to explain how 2 of those breaches are not material, and those were the breaches by MLP. It does not discuss how the estate's breach is immaterial. In fact, it talks about that breach first. It seems to put the paramount importance on that breach. But it's not just semantics either. Substantively, looking at the ruling, you would come to the same conclusion that the estate did materially breach the agreement and that the other breaches were not material. The breach that the estate had was that it was not able to produce marketable title. That was the essence of the agreement, as the case law says. What constitutes material breach? It goes to the essence, the object of the contract. The estate was not able to produce that, and therefore the breach was material. That's what MLP was bargaining for. On the other hand, the estate, it was not bargaining for a title search or a certain type of notice. Those breaches were breaches, but they were not material. And the court found that and accurately found that. So we would submit that both linguistically and substantively, in reading the trial court's opinion, you will see that the estate materially breached the agreement and was the only party to materially breach the agreement. I also would like to draw the court's attention to language that we used in our brief that I do not think was the most accurate. I think we overstated, or maybe we oversimplified the trial court's ruling. On page 14 of the appellee's brief, we state that the trial court concluded that Bowers should prevail in equity. Well, the ruling doesn't say that Bowers should prevail in equity. What the ruling says is that for the estate to keep the earnest money, in addition to the property, in addition to its judgment against Charles Mounger, would be a distinctly inequitable result. We would submit that that is commentary on the part of the trial court to quote unquote soften the blow for the estate. Because again, the trial court did not think there was any bad actors outside of Charles Mounger. It did not think the estate had bad actors. It did not think MLP was. And therefore, we would submit that some of the language they used was softened, and it was used to explain why it came to the result. But it had already established that the estate had breached the contract, had materially breached the contract. And even from the language right next to that, it shows that the trial court said, pursuant to the contract, they're also entitled to attorney's fees. So obviously the trial court did find that in contract, the ruling was in contract, and found that the estate breached it. And I just wanted to draw the court's attention to that because that was our error, and I didn't want our mistake.
Do you agree then that if the trial court relied on equity to resolve this contractual dispute, that was error? If that was the basis for the trial court's decision, was equity?
So we would still, if that was we would still, the ruling right now as is correct. In the sense that the conclusions that the trial court came up with is correct. I don't know if it would rise to the level of reversible error, but we would agree that yes, the Bowers should prevail in contract.
All right. In other words, you're relying upon the contract and not equity.
Yes, we are.
All right.
I noticed that I am running low on time, so I have one other brief issue in response to the appellant's reply, so that we could get our position on the record, which was that Katherine Lassiter, Harlan Rice testified that Katherine Lassiter agreed to return the earnest money to him. Originally, the trial court and the appellant said, well, that's not sufficient because you need mutuality of consent between the co-executors. In Pritchard's treatise, he says one co-executor can bind the estate. In response, the appellant says, well, that maybe they're not conceding the point. Even if true, though, Harlan Rice was not an employee at the time of MLP. That's a non-issue. Whether he is an employee of the LLC or not, he can still be the authorized representative. His testimony, and that's in Exhibit 9, his testimony was that Greg Steele asked him to make the request. Greg Steele, a member of MLP, asked him to make the request of Katherine Laster to return that earnest money. So she was making that representation to an authorized representative of MLP and Harlan Rice. The fact that he was no longer employed there is not an issue to whether he can be an authorized representative.
Anything further?
I have nothing further, but happy to answer any questions from the judges.
All right, I hear none. Mr. Fansler, you have your time for rebuttal.
Very well, thank you, Your Honor. As to the attorney's fees that Mr. Konvalinka mentioned, one of the issues we raised was the trial court awarded in excess of $40,000 in attorney's fees incurred on the first appeal. And our argument is simple, that they didn't ask for it. It wasn't an issue raised in that first appeal. The Killingsworth, a Supreme Court case, and then Raines Brothers Court of Appeals case say clearly that that has to be raised in the Court of Appeals in the first instance. And no authority was cited by the trial court contrary to that, nor was any authority cited by the appellee contrary to those two cases. So we think the trial court erred in awarding $40-some thousand in fees incurred on the first appeal of this case. Now, as to the credibility of Harlan Rice, if you look at Mr. Rice's testimony and his deposition, and you all are in as good a position to judge his credibility as the trial court was, because he only testified by deposition. Mr. Rice at one time said that he didn't know that Charles Mounger was claiming this, that he owned this property until October 31st, when the meeting occurred with Mr. Anderson and the lawyers and the executors and so forth. And then later he admitted, well, yeah, I did know by the time that Mr. Steele exercised the option to extend the 30-day period. And then he finally said, well, I did receive that email, but I sent it to Ms. Laster. Now, Ms. Laster is one of these folks that keeps every email she's ever gotten. When he claimed that, she reviewed her emails. She got one email from Harlan Rice in August and had nothing to do with the Charles Mounger claim nor the interference with this geotechnical surveyor.
Did she testify in person?
She did. And
so the trial court certainly was in a better position to make a credibility determination as to her than we would be.
Well, the trial court, I don't recall, Your Honor, making a credibility issue about anyone except for saying it was hard to believe that Archie Carpenter wasn't told on August the 3rd that Charles Mounger was claiming this. I don't recall anything in the record about the trial court saying, I don't find him to be a credible witness about any of them. He just said, I find it hard to believe that Mr. Carpenter didn't know that. Well, if that's the case, then Mr. Anderson knew it. Mr. Anderson testified, and he never said it. He told Archie Carpenter that on August the 3rd, or August the 2nd, I guess, when he left the voicemail. Now, Mr. Rice, I mean, he shows up 2-3 years after this is supposed to close. Did he tell Mrs. Laster that he was there as an agent? There's no testimony to that. He says Steele asked him to do it, but he wasn't an employee anymore. And as Mr. Konvalinka pointed out, he didn't stand to gain anything from that. So what? It's like the old demurrer. And as to the return of the earnest money, I put that on me. Mr. Konvalinka's father is a hard man to try a lawsuit against. And she didn't testify that she did not agree to return that money to Harlan Rice, but like I said, Harlan Rice was a stranger to the whole thing at that time. MLP had been in bankruptcy for 2 years. As to this 2012 case, I can't respond to that. I looked at the appellee's brief. That's not cited in the brief. I can't argue something that I haven't seen. This is the first notice of what the trial court found in 2012 in an unrelated case. So, but I just leave this with the court. If the court believes that everybody knew in August of 2007 that this was going on with Charles Mounger, we didn't deliver the a marketable title. There's no question about that. But it just doesn't seem right, and in the spirit of this agreement, that you can hide a defect, say that you're going to accept the defect, you're closing regardless. And I bet you if Charles Mounger hadn't encountered that bank appraiser, we probably would have closed on November the 7th, 2007. So if this is acceptable conduct in a purchase sale agreement as this, then we lose the case. It's that simple. But I don't think the court will find that this behavior of MLP was acceptable. Thank you.
All right. Thanks to counsel for both sides. Case is obviously very well briefed and very well argued. You made the issues clear and your party's position is very clear, so we appreciate that.
Thank you.
Mr. Hibner, if you'll please recess court till 1:30 this afternoon.
The court is now in recess until 1:30 p.m.